They are what?
They are very clear.
Oh, good. Thank you very much. That's great. No,
I
I
think
think
the slides are clearer than you.
it's quite useful, I think, for people to have that sort of aide memoire. So
Very,
anyway, so then you'll call on me to start, and so I'm speaking for. Now the thing is, obviously, it's such a huge subject, but I mean, I was thinking, should I speak 30 minutes, 40 minutes,
Yes,
something like that?
that's precisely what we're looking at. 30, 30, 35, 40 to each speaker. And then we open it up to questions.
Yeah.
Professors of the society, well, the faculty advisors of the society will join in as well. And students and other participants and members of the society who are also students will join the YouTube link. So we'll get a set of questions, and if they're addressed to someone, then they can choose to answer them. Otherwise, uh, we just see how we go with the flow.
Excellent. And just in terms of numbers that you've got coming, what are the latest numbers?
Well, here we have five, and the others will join the YouTube link. So we're looking at around, we've got at least 50 members of the society itself. So
Yes.
the numbers will be more focused over the YouTube link.
Yes. So we're
very,
just keeping this on this link here, and we'll be joined by my
Yes, yes,
associate Dara,
that's
who will
fine. That's
come
perfectly
along in a
fine.
moment.
That's
But
perfectly
apart
fine.
from that, so that's perfect. So after, will you have, will Anil, will you then go after me, and then we have questions after both of us?
yes.
That's right. That's right.
Yeah.
William, I will give the Indian perspective of things
Yes.
because a lot of people, for a lot of people, your subject will be very new, and
Yeah.
your perspective will be something which is quite knowledgeable and new to them. So I have to bring in the equalizer. I have I have to put things in the perspective where people are on one to one. See,
Yeah, and it's a bit more on home territory.
we are still holding on to the vestiges of the Matrimonial Causes Act of 1857
Yes.
in the Anglo-Indian Saxon jurisprudence. And yesterday I was
Well,
arguing before the
yes.
Supreme Court that it's time we moved on to shared parenting. We stopped talking of singular custody.
Well,
And
as you would have seen from my slides, I'm going to be talking really about financial matters, and I'm not talking really about children matters because in the time I can't. I'm just touching on them at the end, and just talking about the areas that we have to look at as international practitioners. So I'm really talking about the civil law, common law concepts, the differences, the issues that we have as international lawyers dealing with finance on divorce mainly, which I'm hoping is not going to be too technical, so that it will be something that people will find interesting, even if we're not going into a lot of detail on it.
William, I would suggest you stick to the periphery.
Yeah,
Please avoid getting into more technical details because people will not understand it.
yeah.
And we do not have a very developed family law jurisprudence as of yet. We don't
Hmm.
have we don't have a family law division in the High Court, though we have family courts at the grassroots level.
Yes.
So we really haven't developed a family law practitioners or a family law teaching jurisprudence.
No.
I slowly see more evolving issues and a lot of interest because of increased litigation and a lot
Yes.
of concepts coming in. So therefore, surrogacy, adoptions, marriages, divorces has
Yeah.
brought in questions which statute doesn't answer. See, that is our biggest issue, where you have done better. You have gone into same-sex unions. You have gone into uh, surrogacy act. You've gone into the Children's Act. I mean, you have developed into so many things. I know this because I deal with cross-border reports, expert advices, and a lot of references on from boroughs and councils about what to do with children who need to be put back and forth.
Yeah.
So, so your perspective from that score is very interesting, and you know, IFL should be looking at an uh, drafting a bench book on international family law.
Well, we have got this book which I'm going to mention called Family Law: A Global Guide,
Wow.
which is the one by Thomson Reuters.
Wow.
And it's quite a good book because it does set out the sort of general law in lots of different jurisdictions.
And William, just to,
James Stewart edited it.
okay. William,
Is that the one?
This is our latest work.
Yeah, I know. I've seen that.
You're on the jacket.
Yeah, I've seen that. Yeah, that's very exciting. Yeah.
It's 900 pages. It's our best work.
Yeah, I mean, honestly, your contribution to international law, and I'm going to say this, has been quite exceptional, I must say.
You know, this was the need of the day because I have touched on nine subjects, and this came because I was asked by the Judicial Academy of India to do a program on problems of non-resident Indians in the legal perspective with this family law and other issues. So I developed this course there and worked on it for 6 months. And then I thought that this material, but was good for a book. The idea was very catchy and very enticing. But the version of the book, William, took a year. Because so many things are evolving now. There are judges coming out with new concepts. There are some amendments in some laws. So updating it was a big issue. It is in 9 parts. So I can edit, add, subtract to the parts. And every part is separately paged and indexed.
Yeah.
That's the better way of writing a book now.
I mean, it's
on Kindle and Amazon. But William, the culture of books is going. It's fading out. It's very difficult finding a publisher. LexisNexis has practically wiped out all small publishing houses.
That's true.
And it's only law commentaries or used by students or help books which are actually being printed.
Self-help books, exactly.
So the features are common, and you know the instinct to use the internet for anything, a judgment, a citation, a statute, is so strong among the younger people.
Yeah.
Gone are the days when people read law books. I mean, I would love reading a law report, finding a law report in the first instance. I remember when I was at SOAS in 1985 and at the Institute of Advanced Legal Studies in 86, we used to use the microfiche.
Yeah.
Stuff.
Of course.
Yeah.
I remember those days of the microfiche.
William, I have 3 rooms full of law reports. I used to subscribe to about 15 of them till about 5 years ago. It's all stopped now because now you buy law packages, Law Finder, online, SCC Online, Manupath.
Exactly.
And you know, there is a newer version with keys, which means you're not dependent on the net. The ones with the net can slow down if your internet fails. But the ones with the keys, you can log on to your computer after you downloaded your software. And you get an update on the screen, and they're much better. They're hassle-free vis-a-vis the internet issues.
Interesting. I mean, I must say that I still get the hard copies of the family law reports in England, but I'm afraid that they remain in their plastic covers, which is really a terrible waste of money because, of course, everything is on the internet and I just access it through that if I wish.
I know. You know,
That's the thing.
I'm reading the journal of the IMFL, which Lord Thorpe brings out to the young man.
Yes. It's International Family Law, the Jordan's one.
It's nice because the articles are short and you can run down the whole thing over a meal just to get a
It's true. Also, it doesn't come out too often, so you're not inundated with it. Have you heard from Matthew Thorpe recently?
Well, haven't of a late. We were in touch with him regularly, but the contact has stopped. He must be in the village. I guess I hope he's doing well. I
I'm
haven't
sure he's fine. I would have heard if anything had happened to him. He'll be in his house in Wiltshire.
Yes, a strong man. I think he's very
I think he's healthy.
he's healthy, and he's strong enough to survive on his own. He's
Oh
very
yeah.
independent. He's not the one to look for supports. And he was always very clear. But
Mm.
we all
It's sorry to cut you out. It's 5 o'clock. Shubhamji, can we go live now, please?
Sir, we are already
All
live before
right.
10
Okay.
minutes.
Sorry. Well, good morning, good afternoon, and good evening to all those watching. This is the first inaugural lecture of the Jindal Society of International Law's lecture series, Futurism and Futurism of International in Future of Internationalism and International Law. And this really is a brainchild of Professor Dr. Westlin Popowski, who's the faculty coordinator of the society. And unfortunately, Professor won't be able to join us today, but he sends his best regards and wishes. Professor Popowski, for those who don't know, is the senior faculty member at the Jindal Global Law School. He is the member, he's a part of the advisory board of the Journal of International Humanitarian Legal Studies and the editorial board of the International Studies Review and Sustainability Science. He's contributed to over 2 major international initiatives, and his research work focuses more on international humanitarian law and environmental law. He under his center, which is the Center for the United Nations, the society is being formed. The Center for United Nations aims to develop a learning platform on opportunities and limits of the United Nations by enhancing research and building knowledge on how the United Nations systems work, both in terms of institutional development, in terms of promotion and implementation of various multilateral policies. The center fits well within the boundaries of the global vision and global aspirations in the Jindal Global Law School, and also with the OP Jindal Global University, and its commitment to independent scholarship and academic freedom. Um, the society is brand new. It was created on the 18th day. It is formally launched on the 18th day of November 2020, and the society was fortunate enough to have Professor Jose Alvarez of New York University to talk about the Biden administration and international law. The society, which started as a figment of my imagination, got support of my colleagues who formed the core committee and got legitimation when Professor Popowski was kind enough to accept our invitation as a faculty coordinator. Now, today we have a very special set of speakers who will be discussing a very niche area of practice of international family law. For this first speaker we have with us is William Longrigg. William specializes in international divorce, financial relief, including prenuptial and postnuptial agreements, and private law children cases. A number of his clients are ultra high net worth individuals and members of high profile aristocratic international families. And William has won several awards over the years for his work. He is ranked tier one in Chambers in the Hall of Fame in Legal 500, and is listed as a top recommended family lawyer speaker in the year 2020. Our other speaker is Mr. Anil Malhotra, who is a practicing advocate of the Punjab Haryana High Court since 1983. He regularly appears as a counsel in the Supreme Court of India at New Delhi and other courts, commissions, boards, and tribunals within the country. He's also taught civil procedure law and matrimonial reliefs for a period of 6 years at the Faculty of Laws, Punjab University. And for 20 years, he has extensive exposure in handling matrimonial, civil, criminal, and overseas litigations on behalf of non-resident Indians residing abroad. Now, I will not stand between the speakers and their views, but before I hand over the virtual floor to Mr. Longrigg, who will be presenting, I have a small quote from a book which I refer to for my quotations in legal essays and articles. And the quote is by Lewis Carroll, who's a 19th century author. Lewis Carroll wrote very famously, he said, "In my youth," said his father, I took the law and argued each case with my wife, and the muscular strength which it gave to my jaw has lasted for the rest of my life. Now, with those words, I will hand over the floor to Mr. Longrigg, and I will now screen share because he has very kindly prepared a set of slides which he would like to share with us while he presents.
Can everybody hear me?
Yes, William, you're loud and clear.
Excellent, good. Thank you very much indeed. Ankit, thank you very much indeed. A very good evening to you. Of course, it's morning here. It's not quite 12 o'clock yet here. I'm really happy to be asked to give this talk to you. And I'm really happy to be asked by Ankit Malhotra, whose father and uncle are very high profile figures in the world of international law and international family law in particular. And they're leading lights in the International Academy of Family Lawyers, which I'm honored to have been the past president of. So I really appreciate this opportunity to speak to you about global family law and international perspective. Should we have the first slide, Ankit? Now look, let's just talk about globalization. Today, I'm going to talk to you about issues that are relevant and important for the international family lawyer. It's a huge area, but I just want to whet your appetite to give you an introduction to it. Globalization has meant that we have much greater communications between different nations. We have an interdependence in respect of goods, services, technology, and so on. Now, I do feel a little bit of a fraud saying this when the UK has just spent billions of pounds and many, many hours in extricating ourselves from the European Union, something which I am not happy about, because that was an organization which was outward looking, which was actually a very useful club, and which frankly did a great deal of good. And over decades, we've built up reciprocity between various different EU countries, which now, as far as the UK is concerned, has been thrown away. But I don't really want this to be a political diatribe. So enough of my politics for the time being. The point about it is we are globally different countries, different jurisdictions, having more and more interaction with each other, and international aspects of family law are increasingly important. Now, when I first joined my firm, Charles Russell & Co., 35 and a half years ago, I was an article clerk, I did my training there. There was not that much international work. It's now increased exponentially. More than 50% of the practice in our family team is international, and probably mine is more than 70%. So we need to know about it, and to a degree, you need to know about it. It's a huge subject, and I've got to try to work out in my own mind what you might be interested in hearing about today. And so I'm just going to be touching on certain areas. And I suppose inevitably there's going to be crossover in these various areas. But what I'm going to concentrate on essentially is finance on divorce. In other words, how the courts around the world deal with financial issues in the context of divorce, and how the international interactions work and what considerations we need to bear in mind. I'll touch briefly on children issues, but this is mainly what I'll be discussing, the financial elements. I'm going to be talking about conflicts of law, jurisdiction battles, comparisons of systems for the division of assets and spousal maintenance, civil law versus common law, very important element, prenuptial and postnuptial agreements, duties of disclosure, duties of the court, dealing the English court's ability to deal with finances after an overseas divorce, and then I'll briefly mention certain headings in other areas such as freezing orders, joining parties to proceedings, trusts, Brexit, the Hague Conference on Private International Law, and comparisons of laws on cohabitation, before just giving some headings on children matters. Now, Ankit, I'm going to be asking you to tell me if I go over my allocated time, because I'm going to have sort of 35 minutes. Thank you, that's great. So we've got conflicts of law and jurisdiction battles as the first slide. Now, of course, This is to do with trying to establish the appropriate jurisdiction to benefit your client. Which is the best country for your client to get divorced in? This is a lot of what my work is about. In one way, it's the most important element for lawyers practicing in an international arena. That's what they need to know. Which country is going to be best? Now, we're not allowed to advise on the laws of other countries, but of course, we do have to know that it may be incredibly important for a client to seize the jurisdiction of one particular country. So we've got, can you just go back to the previous slide? Sorry, that's it. So we're talking about getting advice from the laws of different jurisdictions. We have the International Academy of Family Lawyers, which I've already mentioned, where we have many contacts throughout the world who we can discuss matters with. And we can ring a friend and say, look, is it better for this client to get divorced in the US, in this particular state, or in England? And that's really the first step. And then we have Brussels II. Now, this is a European instrument, which was part of the European Union group of instruments that we entered into. This has been very important for Britain over decades. Essentially, the rule here was the first to issue seizes the jurisdiction. So if you issue divorce proceedings in England, and there's a possibility of there being a divorce either in England or say in France, then England got the case, which also meant that it dealt with the finances. So for example, and I'm just giving you an example here, there's a reported case called Clammers. We were approached by a woman at 5 p.m. on a Thursday. She came into the office. She said, I'm French. My husband's French. We've been living in London for 28 days. He's going to France tonight. He's going to issue divorce proceedings in Paris tomorrow morning. I don't know what to do because I don't know whether he's therefore going to have an advantage over me. So we said, we know that if you issue divorce proceedings in England before he issues them in France, then England will have the jurisdiction and you will get a better deal. In that case, we issued first thing in the morning. In France, they issued first thing in the morning. We spent 1 year in trying to decide who was first in time. In the end, the French court said they couldn't tell whether they were first in time because they didn't believe the evidence of the French lawyer, and I'll come on to that later. So therefore, we won the point, and the wife got £10 million more in England than she would have got in France. So we always have to have our wits about us. First in time is only definitive as between EU countries, which we no longer are. So the whole point of this argument of forum conveniens, which is what is the most appropriate forum, is also argued about, which is the most appropriate place for a divorce, bearing in mind the various connections. And this is a lot of our work. Now you say, well, surely this is about finance, not about divorce. It doesn't matter where you're divorced. It's true that it doesn't, in a sense, matter where you're divorced, because divorces tend to be recognized throughout the world. But nearly always, the financial consequences of divorce follow the divorce itself, and therefore are dealt with in the same country that the divorce is taking place in as a matter of law. There's a big danger here that people who don't understand the law are being asked to advise on these international matters. And this is one of the reasons that we have the International Academy of Family Lawyers that is teaching people throughout the world about international considerations and what they need to look out for. Lots of lawyers are nervous about doing international law, but if you're ever thinking of doing family law, I would say be an international family lawyer. It might be scarier, but it's really, really interesting. So let's look at the reasons for choosing one jurisdiction over another. If we could have the next slide, please, Ankit. So attitude towards spousal maintenance. This is very closely related to what I've been saying before. Now, the we have a book here called Family Law, A Global Guide, which is edited by a chap called James Stewart, who's again in the International Academy. And this gives sort of guidelines about which law is applied by different countries. But essentially, we really need to know about how a different jurisdiction will deal with legal issues by speaking to the individuals there. One of the matters which is absolutely clearly very different between various jurisdictions is the award of spousal maintenance. And so we can see that in some countries, spousal maintenance does not exist really as a concept, such as Texas, Scotland, Sweden, and Finland. It just doesn't really exist. Whereas in England, Canada, Switzerland, spousal maintenance is alive and well. And also, as between us and particularly civil law, and particularly mainland European jurisdictions, there's a huge demarcation, which I'll talk about later, between the concept of maintenance, which is really support and need-based awards, and property, which is the division of assets. In common law jurisdictions, such as ours, such as India, such as England, really money is money, and there is not such a demarcation between maintenance and capital. But I mentioned this business about spousal maintenance because many people are afraid of the English courts because of the very high levels of spousal maintenance that are awarded there. And also, spousal maintenance is often, in fact, usually capitalized in England. And that is not what's done in very many other jurisdictions. So I can't go through with you any detail of different attitudes in different countries, but there are a few important principles. So here we have civil law versus common law jurisdictions and matrimonial regimes. This, again, is fundamental to the international lawyer. You probably all know the derivation of common law, which is this concept essentially named because it was common to the law across England. It was a unified system of courts brought in by Henry II in England in the 12th century. Of course, there are some fused and combined systems, but broadly speaking, common law jurisdictions are about a third of the world's systems. Civil law essentially originated in mainland Europe. It's adopted throughout much of the world. Of course, it came from the corpus juris civilis of the Roman Emperor Justinian. This is the most widespread system in the world. And of course, civil law is a more rules-based, non-precedent-based system. Anyway, the two systems are, of course, far more similar than they used to be, many crossovers, but the fundamental differences need to be considered, particularly by the international lawyer. So the concept of property regimes is a very important element. Essentially, most civil law countries, and of course some common law countries, have this system of a matrimonial property regime, which is a legal regime which kicks in automatically on marriage, may be deferred, but nevertheless it kicks in on marriage, and clearly sets out the ownership of the family assets and will be likely to be enforced in the event of a divorce. So in France, for example, the default matrimonial regime is community property, which essentially means everything created during the marriage is to be shared equally, jointly, regardless of whose name it's in. That's the default régime matrimonial. But most people, or many people, I should say, enter into a separation of goods marriage contract to say that actually the ownership will be on the basis of whose name the assets are in. So they get out of the community property regime in that way. And that's really how the concept of the prenup emerged. So without going through property regimes country by country, suffice it to say, the default regime is very likely to be an equal division of what's been created during the marriage. Some countries like Sweden They include assets that existed before the marriage. Very few countries have a default regime of separation of property. Most common law jurisdictions do not have property regimes in that sense. So as I say, these regimes have given rise to prenuptial agreements or marriage contracts, which will replace the default regime. Those prenups or marriage contracts are unlikely to be interfered with by the court. They're just seen as a way of dealing with the property. In common law jurisdictions, or most of them, there's far more discretion generally about what happens when we're talking about the division of finances on divorce. And I will be talking in a bit more detail about prenups, but I do want to talk about discretion generally. In most civil law jurisdictions, there are rules about how family finances are dealt with in the context of divorce. But in common law jurisdictions, so for example, in England, we have the Matrimonial Causes Act 1973, which of course lists a number of matters that the court's got to take into consideration, and it's got to use its discretion in the context of the length of the marriage, the needs of the parties, respective contributions of the parties, and the extent of the resources, standard of living, the health, with the first consideration being the welfare of any of the children. Now, I've mentioned here in the slide the case of White and White. This is a very important case from the year 2000, where the court suddenly said that instead of everything being dealt with on the basis of what the financially weaker party reasonably required, actually we were going to have a system where the starting point is a 50-50 division of what's been created during the marriage. In other words, the marital request. We thought, oh, we're becoming all civil law, are we? But in fact, the court exercises its discretion so often away from an equal division, particularly for financially weaker party who's looking after the children. So a wife might easily get significantly more than 50% of the assets in order to continue to house the children. And this is really something which has changed the way that we look at things, but the discretion is still very much there. Discretion reigns. But in most continental jurisdictions, for example, the job of the court is to put the matrimonial regime into effect, often with the help of an accountant. And then the question of maintenance is dealt with quite separately. So I've mentioned here that in France, they have a thing called the prestation compensatoire. It's a method of working out spousal maintenance that, frankly, I don't understand, and the French lawyers tell me they don't really understand it. It's usually done on the basis of a calculation for a maximum of 8 years of support. And then, you know, for example, the Dutch work out spousal maintenance with a formula based on the length of the marriage. And as I say, most Nordic countries do not grant spousal maintenance. Now, I've put down here attitudes, duties, and obligations of the court under the civil law and common law, because in civil law, in most civil law jurisdictions, the primary duty of a lawyer is not to the court, but to the client. Whereas in England and Wales, the primary duty of a lawyer is to the court and not to the client. So in many civil law jurisdictions, it is okay to say something to the court which you know not to be true. And I'm coming on to that later, but this is a very important element in our international dealings. Slide 4, please, Ankit. So prenups and postnuptial agreements. I've already, of course, touched on these. This is a significant part of our practice, particularly of our international practice. Most of the prenuptial agreements that I do are designed to be binding in more than one jurisdiction. England, as I say, has a reputation for very generous awards to the financially weaker party. So a lot of rich people are trying to protect themselves from this dangerous, wicked English family court. Often they also want to be protected in Russia, France, Switzerland, Australia, New York, or wherever it might be. Now, when I started practice 35 and a half years ago, prenuptial agreements didn't really exist. They were regarded by the courts as contrary to public policy, so they would not be upheld by the court. Typical English or British arrogance, say, oh, well, they're just not British, they're very continental. Things have changed dramatically. It's partly because so many people from civil law jurisdictions live in the UK, particularly in London. So pre-Brexit, there were, for example, supposedly 600,000 French people living in London. London has a population of 8 million. 600,000 is a pretty big proportion. It was actually France's 6th city. And that just gives an indication of the number of people from overseas who are living there, which is why we have the practice that we have. I've mentioned here the case of Radmacher and Granatino. This was a case where a French banker married a German heiress. They had a marriage contract in Germany, and really the facts of the case are not so important, but the UK Supreme Court set out the various rules which were applicable to drafting prenups. And in short, if the prenup is signed not less than 28 days before the wedding, there's only minimal pressure to sign it, there's independent legal advice on both sides, thorough financial and other relevant disclosure, and it's fair, then it's likely to be upheld. So again, discretion of the courts, classic common law system. We'll look at it, we'll probably enforce it, but we reserve our position. So walking the tightrope of English law requirements combined with the tighter obligations of civil law jurisdictions can be a real issue. Spousal maintenance, for example, can that be included? In nearly every civil law country, they do not allow spousal maintenance to form part of a marriage contract or a prenuptial agreement, Germany being an exception. In many common law countries, of course, we have the concept of prenups, even though they haven't adopted the idea of property regimes. So in practical terms, we find it a difficult thing to do, and many lawyers do not like doing prenups, particularly in the US and in Australia, where many lawyers have been sued for getting it wrong in prenups, thinking that they were creating something binding which hasn't been binding in the end. So next slide, great, thank you. So duties of disclosure, duties to the court, and ethics. This sounds like quite a boring subject, but I have to say it's really quite interesting. Now, one of the reasons that London is the divorce capital of the world is that the methods for forcing people to disclose their assets and resources are so significant. And the Matrimonial Causes Act is very clear. It's not just assets, it's resources as well. It's what might be available to you, even if it's not in your name. Trusts, for example. So the system which exists for unearthing the details of somebody's resources are very well known and are very extensive. So the family court in England has the power to make adverse inferences in respect of non-disclosure. The case of Livesey and Jenkins sets out that there's a duty of very full disclosure. This is not a duty shared in every jurisdiction. In England, the courts can send people to prison for not providing disclosure or for lying about their disclosure. This is not the case in very many civil law jurisdictions. The courts do not have that power. They don't have the power to punish people who lie in court. And this is a real consideration when you're trying to decide which is the appropriate jurisdiction for your client to get divorced in. So again, I've talked about the case of Clamers, which is this French case that we did, where the French court expected the lawyer not to tell the truth because the lawyer would be saying what was appropriate for the best case scenario for their client. That could not happen in England because you'd be struck off if you said something to the court that's not true. So there's a very different procedure in the civil law jurisdictions from the common law jurisdictions for getting to the bottom of the finances. In the civil law jurisdictions that I deal with, mostly Europeans, there is not a thorough system for getting to the bottom of somebody's finances. There's a déclaration d'honneur where somebody's supposed to set out their finances truthfully, but even if the lawyers know it's not true, they're entitled to put that document before the court. Now, the other thing is, for example, that we have final hearings for dealing with finances on divorce that might last for 2 days, might last for 3 days. In France, they are supposed to last for 7 minutes. If you know the judge, you might get half an hour. It's dealt with on paper. It's a completely different system. They're not expected to create a great analysis of somebody's finances. They leave that to some degree to the accountant, but it's not something which is dealt with by the judge or dealt with by the lawyers in court, to a degree on paper, but only to a degree. But there is a question: is our English system, which is shared by many common law jurisdictions, too cumbersome, too expensive, too complicated, too uncertain, with too much discretion? But is the civil law system too rules-based and therefore not fair enough? Should we go on to 6? This is just an interesting bit of law that I'm throwing in here, because a lot of people who are lawyers in England, even doing family law, do not know that this exists, and many people in other countries don't know this exists. So even if there is a divorce in another part of the world, the English courts have the power under this act to make a financial order after an overseas divorce, even where financial provision has been made overseas. This is powerful. The English are heavily criticised for having this law, particularly by mainland Europe, who again regarded as typical arrogant British, that we think we can just overrule things. It was actually dealt with, it was brought in mainly to deal with cases from the Middle East where people were able to be divorced in certain countries, often via talaqs, where the financially weaker party, the wife, would get nothing, but she lived in England. And then the court said, well, you know, it's not fair that we can't deal with this just because there's been an overseas divorce. So it was brought in for that. But then cases like Agbarji, which I mentioned here from 2010, says, even if you got a reasonable settlement, and this one was a settlement which the wife had got in Nigeria, even if an order was made, we can actually revisit that if necessary. Now, you need to get permission from the court. It's quite complicated, but quite a lot of our work is advising people on whether this is an element or this is a law which they can benefit from in England. And it's a very interesting process, and there's some very interesting law on it. Should we just go to the next slide, Ankit? This is a major part of an international practice, freezing orders. This is a reason people don't like the London courts. It's hard to get freezing orders, but we can get them where necessary. Again, a worldwide freezing order obtained in England does not freeze all the assets throughout the world, even though it says it does. In other words, a bank which is based in Zurich is not under an obligation to take notice of a freezing order which has been obtained in London. So often we have to go to a number of other jurisdictions and obtain freezing orders in those jurisdictions. Complicated, difficult, and expensive, but again, an important element of our work. This is normally made ex parte. You go before a judge without the other side, but nowadays you're expected to give notice to the other side so that at least they have an opportunity to attend, and the judges nowadays will want to know why you haven't told the other side, even in a situation like this. Next slide. Joinder of third parties. This is, again, something we have to deal with and consider a lot. It's a dangerous thing to do, because if you bring somebody in to a case as a third party in a divorce case, you may end up paying their legal costs because they've got to get separate representation. You don't normally bring people in for the purposes of disclosure. You might bring trustees in order for an order to be made against them, or other individuals who've provided, for example, money for the family. And again, there are international considerations to do with enforceability against third parties, which is something we certainly have to deal with on a regular basis. Next slide. Trusts. A lot of people find it hard to accept that our courts have the power to vary trusts, because they say, this isn't my asset. I might be a beneficiary of this trust, but it is not my asset. And we say, sorry, it's your resource. And the relevant word is resource. Now, the English court under this section here that I've set out only has the power to vary trusts, which are defined as antenuptial or postnuptial settlements. Nothing to do with prenuptial agreements, by the way. This is a whole different concept. So you've got to see whether a trust in your case falls within this category. So trusts made during the marriage or at the time of the marriage usually are nuptial settlements. Trusts made a long time before the marriage, is what we call dynastic trusts, normally are not. So if they're not, then the court doesn't have the power to vary them. I've mentioned the case of Thomas and Thomas here. This is because the court has two attitudes towards trust. One, shall we vary it by making an order against the trustees? Two, shall we just treat the assets as a resource so that we can make an order against the beneficiary on the basis that the beneficiary will then go to his or her trustees to ask them for money? So that these two different approaches, again, very important for the international practitioner because many trusts are based overseas. Do we really want an order varying a trust which will never be enforced by the trustee or enforceable against the trustees, for example, in Bermuda or in the Cayman Islands? Very possibly not. Trustees are very reluctant to give disclosure about their trusts, and we often have to get orders in other jurisdictions against the trustees to provide disclosure. The message here is the family court has the discretion to look at the reality of a situation. So even if somebody is a beneficiary of a trust along with other people, and they say, it's not mine, it's just a discretionary trust, if they have received significant payments whenever they have asked, the reality is they have treated the trust as their own assets, and that will be taken into consideration by the court. Civil law countries find it difficult to understand this, and that's a major consideration when you're deciding which is the appropriate jurisdiction for your divorce. And I've already mentioned enforceability. Next slide. Brexit and European instruments. Now, this is just a heading here because it's a massively complex issue, but a lot of our work has been to do with this. Not so relevant for you at the moment, but very relevant for me, because of course we are no longer part of the EU and we've adopted the law set out in these instruments, but we no longer have a place at the table in formulating and reformulating this law. And so we're going to be struggling as years go by as they make the law without us. But point 11 here, the Hague Conference on Private International Law. This has in a sense taken over from the EU as far as England, well, as far as the UK is concerned, because the EU had a lot of instruments that were very similar to the Hague, to many of the Hague conventions, such as service and maintenance and other conventions. And that's really going to be, they're going to be even more powerful. The Hague Conference on Private International Law is a fabulous organization run on a shoestring, but internationally extremely important, not just for family lawyers, but for many other areas of the law. The best known convention by far is the 1980 Hague Convention on Child Abduction, which I know is very close to the heart of Anil Malhotra, who has really been working very closely with the powers that be in India in respect of this, and I dare say that he will say something about it. I'm just briefly mentioning cohabitation. Cohabitation, we do not have laws in England dealing with cohabitation. Cohabitants have no rights against one another. Mrs. Burns, who was a woman in 1984, She was called Mrs. Burns, but she was never actually married to Mr. Burns. They had 4 children. They separated when all 4 children had grown up. She had no claims against him, even though they had been together for 35 years. This is constantly under review, but we do not know whether it will ever be changed because it's not really a vote winner. We're lagging behind other countries. The only basis on which cohabitants can get an award is if they have a child. They can make an application under the Children Act for support during the minority of the child, or if there's been some promise in respect of property, they can go on the basis of resulting trust or constructive trust. So we're behind on that, and I regret it. Next slide. Children issues, I'm really just going to give you these headings. Hague, 1980 and 1996. I've already touched on this, is to do primarily with child abduction, but also parental responsibility. And then custody, parental responsibility and child arrangements. This is a lot of the work that is done by all family lawyers throughout the world. And of course, where there's an international element, it's that much more complicated. Habitual residence is a concept constantly under review in terms of its definition. Case law changes the definition of habitual residence time after time because it's absolutely fundamental in international family law work relating to children. Relocation is a major part of my work where, for example, a mother, a wife and mother wishes to return to her home country, whether it be India, whether it be Australia, whether it be California. These are applications that we have to deal with the whole time. The English courts have been criticised for letting people go back home too readily. Things are changing a bit and it's becoming more difficult for people to change countries. But the idea is a child cannot be taken away without either the permission of the other parent or an order from the court. So adoption, again, international adoptions, very specialist, very important area that we're involved with. And of course, surrogacy. Again, you know, we've done a lot of work on surrogacy, and there is a huge difference in the attitudes of various different countries towards surrogacy. I know there's been a huge change in India not so very long ago. We have 2 judges who deal with all the surrogacy cases in England, which is very good because it means that they are specialists. But still, it's a complex and difficult area. So I don't know, I think that might be it. So thank you very much indeed. I don't think I've overrun too dramatically. So I'm glad that we at least managed to touch on those areas, and thank you very much for listening. And I will, of course, be here to answer any questions after Anil has spoken. Thank you.
Well, thank you for those words. And as we were moving along, two points sort of struck with me is this expansive interpretation, or rather use of this use of territoriality in the British courts. And the second point was, as you very rightly mentioned, the UK being the divorce capital of the world. And one case which is particularly caught my attention is on a rather different topic of jurisdictions and immunities of diplomats. Is the case of Al Jafali, who was a Saudi billionaire, and he got involved in a nasty divorce proceeding, and then he claimed diplomatic immunity to wash away his hands. But the civil court said that you can't have a veil of diplomatic immunity in civil claims. So those are the sort of points which stuck with me. I'll now ask Mr. Anil Malhotra to proceed. I will share his presentation now, and we can take it forward from there. I can't see his presentation now.
Before we come to the presentation, I can speak offhand a little. William, thank you very much for the brilliant exposition which you have made in a perspective which is alien to a lot of us. We essentially differ because we have a religious based family law. We do not believe in irretrievable breakdown. We do not have prenuptial contracts. We have a need-based maintenance law. We have still singular custody and guardianship arrangements. Though we have gone ahead in some matters of inter-country adoptions, surrogacy, adoptions, and issues relating to domestic violence, where live-in relationships are recognized as relationships in the nature of marriage for purposes of maintenance. So I am going to deal with 10 principal issues which I think are the cornerstone of international family law in India. We have jumped into, in the past decade, into the realm and pool of international family law, which we previously used to call as private international law, from the terms of Cheshire's commentaries and Dicey and Morris, which we studied as students. But I now see that 30 million non-resident Indians of a population of 1.2 billion Indians living in 200 countries abroad have created a corpus of inter-family disputes which transcend across borders, with parallel matrimonial litigations in two jurisdictions, or residences in two jurisdictions, or relocation and litigation traveling up and forth in the realm of family law when children, extended families, and spouses are involved. So I am going to deal with 10 issues principally. The first being the most hotly contested one, child removal. And then I will step on to marriage, divorce, and maintenance. Then I'll move on to surrogacy. Then I will look at nationality, citizenship, overseas citizens of India. Then I'll look at Indians, foreigners, and deportation, then guardianship and intercountry adoptions, then domestic violence, international perspectives, then overseas Indian succession issues, then enforcement of foreign matrimonial judgments, and last of all, conflict of jurisdiction and anti-suit injunctions. We have recently come out with a book called Global Indians in the Law. It's a 2020 edition. So I have the benefit of updating all the issues with what has come up. We have been slow to catch up, but we are, so to say, moving. Now, one of the most hotly contested issues is interparental child removal. Now, under personal laws applicable to parties, both parents are natural guardians, and there is still a preferential maternal preference for a child of tender years. Though we have a secular Guardian and Wards Act, but it goes back to 1890, not 1980. So we're still living with that colonial law, though the Law Commission has suggested that we should change it, but we are still struggling with that. So in this realm and in this perspective, whenever there is a dispute on the custody or guardianship of a child, we are governed by issues like India is not a signatory to the Hague Convention, interparental child abduction or child removal, like the Hague Convention, does not find definition or recognition in any Indian statute. The detention of a child is difficult to prove. The fallback is expeditiously on a habeas corpus remedy in the prerogative writ jurisdiction of a high court or a Supreme Court. If that does not succeed and requires a trial, you need to go back to the Guardian and Wards Act, seeking to become a guardian or a sole custodian of your own child. The prerogative writ is falling back. But what I have seen developing and what I have been able to persuade the courts is that in the absence of a regime coming through the Hague Convention of a central authority and being a part of a 100 countries network is a mirror order jurisprudence, which was very well laid down by Justice Thorpe at the Court of Appeal and has evolved through British law. And I have been able to recently put it across in a matter whereby an Indian High Court order was mirrored in the US and the children were able to travel back. Now, this would vice versa, if applicable in the reverse, be very helpful if this were to get going. Next slide, please. As I just told you, So this is the golden circle, not the triangle, I would say. We are on a writ of habeas corpus in the Guardian and Wards Act, India not being a signatory to the Hague Convention. So we are still alienated from 100 odd countries who are part of a network. I, with the kind assistance of William, have been working on it for almost 25 years, and I on my own for 35 years with the help of Mr. William Duncan at The Hague and Mr. Hans van Loon, who was the protagonist of the entire movement when he was there at The Hague Conference of Private International Law. Next slide, please. So the position on child abduction law is essentially a court-developed law. So we start with 1984 of a judgment of the Supreme Court saying that children should go back. Then when we do a flip-flop off and on, we follow foreign court orders. Sometimes we don't, we follow the welfare principle, and we came down and settled on the middle order principle. Now coming down to marriages, divorce and maintenance. We are still on a fault-based theory, though we allow divorce by mutual consent. And we do have issues when matters get into rough weather of the matter being sorted out by the Supreme Court using a very extraordinary power. But the question which comes up is breakdown a ground of marriage for divorce? The answer is no. So if you have a foreign court decree on the principle of breakdown of marriage, it's a no. So if you are married in accordance with the personal law in India, you can only get divorced according to the personal law of India, except in the cases where both parties consent and admit to the jurisdiction of a court and readily agree to divorce and readily agree to settle their matrimonial dispute, including custody of children, division of matrimonial assets, etc. But should one party choose to contest or dispute, then the Indian courts do not extend any recognition to marriages which have broken down on account of the breakdown principle. Now, as I told you, we are essentially a religion-based family law. So the sanctity of the marriage is in the nature of a religious issue. There is no element of contract in a marriage. So there is no breakdown principle. There is no prenuptial agreement. There is no postnuptial agreement. And the element of contract or any such issue is wholly out of context in the realm of family law. But we battle with international family law because with a large segment of people living in different jurisdictions all over the globe, the tendency to bring in a divorce by breakdown into India is very strong. So we need to seriously look at issues of changing our law when parties are resident abroad. Next slide, please. Now this brings us to a subject in which we have taken lead all over the world. It's the surrogacy industry is worth 25,000 crores in India with 2 lakh clinics all over the country. It started in 1995 with the Indian Council for Medical Research coming out with guidelines which permitted surrogacy, and which actually through the medical science let this happen for good 10 years. Then we started getting laws in the shape of bills, and views started coming forth, whereby surrogacy was allowed in a limited way. But then India became a hub for surrogacy from all over the world. So whether you were single, whether you were gay, whether you were unmarried, and whether you were living abroad, surrogacy started to flourish in India because there was apparently no law. Now this caught fire when some cases went bad and children born with unfortunate issues were declined to be taken, and that is the time when the government started capping surrogacy. So we now have a 2021 bill after 5 successive bills. We also have another bill trying to control the surrogacy regulation issues. We are still battling with the law having not yet reached Parliament. But as of now, the status is that surrogacy is restricted only to people who are of Indian nationals and who have been married for over 5 years and do not have children born out of marriage, and they have to have proven medical issues that did not allow them to have children in the natural way. But then the larger question is, we have opened up inter-country adoptions through a Juvenile Justice Act amended as back as 2015 to persons irrespective of marital status. So I have often raised the issue that if we were to allow inter-country adoptions to anybody or anywhere in the world as a person, not as an Indian national, irrespective of marital status by legislation, how can we restrict surrogacy only to married Indian men and women and not persons? To put it in a constitutional perspective, the Constitution of India under Article 14 guarantees equality of law and equal protection of laws to all persons. Article 21 of the Constitution guarantees right to life and personal liberty to all persons. It is only Article 19, which is containing fundamental rights specific to citizens, that there is a restriction to citizens. So if Article 14, equality, and Article 21, right to life, is available to persons, any person who is, let us say, an overseas citizen of India or a citizen of India who is now holding a foreign nationality, it would be on a constitutional basis difficult to debar him from undertaking surrogacy in India just because he does not happen to be an Indian national. And trying to impose the condition of proven medical infertility or confining the surrogate to be a close family relative within the family would in my view, not be very conducive, particularly when we have let surrogacy carry on. And if the purpose of surrogacy is parenthood, which is as good as adoption, how can you have two parallel sets of laws made by Parliament applicable in the country when the purpose of the same is almost identical and is meant to give the benefit of parenthood to persons who have not been able to have the procreation through the normal channel, or who have chosen to have a purpose of having children by a method of which they wish to carry on. So it is in this perspective that the Hague Conference on Private International Law may at some point of time have to develop, I believe there is a global workshop already on, may need to develop something on this issue. And we may perhaps, though as we are a participant to the discussion in the Hague Conference on Private International Law, we may also chip in our bit on the issue of surrogacy. Now this brings me to my next slide, please. Now this brings me to a rundown on, next slide, please. Now I will develop on each of these 7 propositions quickly, because these topics, these 7 topics, are essentially what fundamentally the private international law has developed into an international family law in India. Now, we did not want to have a concept of dual nationality. The provisions of Section 9 of the Citizenship Act of India and Article 9 of the Constitution are very clear that dual nationality is prohibited. So the moment you acquire the nationality of a foreign state, you will cease to be an Indian citizen. So we amended the Citizenship Act and we created a secondary status citizenship called Overseas Citizenship of India for the benefit of people who were Indian citizens or who were eligible to be Indian citizens, but who on account of certain reasons have become foreign nationals, are not Indian citizens. So they can be entitled to the Overseas Citizen of India status. This gives them certain benefits notified by the government, but most importantly, this gives them liberty to enter India without a visa at will and to undertake any activity which is otherwise not permissible if you were a foreign national. So this has been a major change, and we are now seeing an amendment of the Citizenship Act recently, where people who came into India from certain territories are being given the benefit of Indian citizenship, even though they were foreign nationals. And in this context, if you were foreigners, you would not be deported. We still have the Foreigners Act of 1946, where we use this provision by a summary inquiry to send people back if they are illegal immigrants or they're overstaying. But this is seeing some modification, and the Citizenship Amendment Act of 2020 and the rules which are coming forth will see some changes coming in. We also have a very enlightened jurisprudence coming in of recognizing Tibetans as Indians. We have over 2 lakh Tibetans who followed the Dalai Lama in 1959, who are in separate encampments all over India. So the Indian courts are now saying that Tibetans who were born in India after 1987, when there was an amendment of the Citizenship Act, are automatically entitled to Indian citizenship, even though they may be holding identity certificates of the Tibetan government, which they obviously will have to surrender. So this is a new jurisprudence in terms of international family law, which allows people of different nationalities to be rehabilitated in India through the regime of enabling family laws and citizenship laws who have strong relationships on family issues. Then comes inter-country adoptions. We have 12 million plus orphan children who need to be rehabilitated. We had an unguided system of adoptions, and the Supreme Court in Lakshmikant Pandey 1, 2, and 3, 1996, 1998, and 1999 came up very heavily on the government to come up with the law on adoptions. So an agency called Central Adoption Resource Agency was created with the Ministry of Women and Child Development and Welfare. It made guidelines. Now, the result has been that in the Juvenile Justice Care and Protection of Children Act of 2015, this has become a major issue, and there are rules on inter-country adoptions, and the agency is now Central Adoption Resource Authority. I may also add to this that we are a signatory to the Hague Convention on Adoptions 1993. So essentially, we have to follow the international system of having a central authority and having a system and procedure by which we recognize the rights of the child. I may also chip in here that India is a signatory to the United Nations Convention on the Rights of the Child, 1989. In 1989, and per se, we had to make a lot of amendments in the Juvenile Justice Act. So now we have a totally controlled system of inter-country adoptions, whereby we follow all the requirements of the Hague Convention of Adoptions of 1993, and it is a very regulated system by which children go from India, go into adoption to countries all over the world. Now, at this point, I would like to pitch in that I have advocated that if we can have a regime of inter-country adoptions through the Hague network, through the central authority, by a process of checks, balances, and controls, why cannot we do this in surrogacy? In surrogacy also, we can have a system of control, we can have a system of checks, we can have a system of putting conditions, and maybe we can even have courts to decide issues like surrogacy. The issue is that we have not developed any laws on surrogacy, and our family laws may not be conversant very much. But our judicial academies can certainly aid and assist in developing surrogacy as a subject which can be deliberated and adjudicated in courts. That brings me to another issue which is very hotly debated and happens in international divorces. Now, whenever there is domestic violence in a marriage abroad, which has been solemnized in India, the issue of domestic violence is raised as a ground to come back to India, maybe with the children, and say, I was a victim, so therefore I need not to go back. And therefore I will be staying with my children here. Now, we have a Domestic Violence Protection of Women Act 2005, and that Domestic Violence Act recognizes relationships in the nature of marriage to give very vast different kinds of relief, rights of residence, rights of maintenance, rights of welfare, rights of custody, which are summarily available by an application to a magistrate without any complicated process in a very expeditious way. But the issue is, how will we settle issues of property, issues of maintenance when when one spouse is abroad and a spouse seeks to issue or have orders issued in India. Now, Section 27 of the Domestic Violence Act confers jurisdiction on a court in India or a magistrate in India in respect of in a place where the woman is residing. But then the question which has been agitated by me in different courts is, if there is domestic violence suffered by a spouse of Indian origin in Cape Town or in Canada, would that domestic violence complaint travel to India? We have not had any settlement of law on this issue as yet, but it seems to be a very debatable question. Whether you can, if South Africa or Cape Town has its own domestic violence act, then you need to agitate your issues there. You cannot travel to India with this. But then the law says it is rehabilitative. If cause of action or a part of the cause of action is accrued in India, then if rehabilitative relief can be accommodated in India by virtue of assets owned by a spouse in India, then that benefit can be attributed because it is a crutch and an aid to a spouse in a bad relationship. Then we come to succession issues. With our huge corpus of the Indian community all over the world, we still remain connected with one thing which is always back at the village or the town or the city in which one belongs to: property. So I own land, I own houses, I own field agricultural property, or I own commercial property, which I left way back 30 years ago with friends, relatives, families, which I have not been connected to. So you often have a second or a third generation Indian with totally foreign cover and foreign roots who's trying to claim property of his father or his grandfather, but has no clue on how to go about it because his father or his forefathers did nothing about it. And if you did have a will, where was the will made? Where was the will registered? How will you succeed? Which law of succession will apply? So I have always advised that if you have properties in two jurisdictions, in India and abroad, you should make two wills because it makes the execution simpler. So if you have property in India, particularly removable property, the laws which will govern you will be the laws of India. So we have the Indian Succession Act of 1925, which applies to you. We also have the personal law, family laws, which apply in case there is no will and you have to go by the personal law applicable to the community. We do have a system of obtaining a succession certificate or a probate of a will if there is a will executed abroad. So if you have a will in respect of the property in India, it is easy to get a probate because the probate or a succession to a will executed in a foreign jurisdiction will be difficult to have in terms of probate in India and to pass on the benefit. But then comes the issue of actually physically taking control. Now, this is something which has not been sorted out. And if property has been in the hands of somebody who has been caretaker or simply grabbers, it may pose very difficult issues. And we have yet to develop a law to handle these issues. Then we come to enforcement of foreign matrimonial judgments. Now, there may be issues of maintenance, there may be issues of divorce, there may be issues of custody, there may be issues relating to division of matrimonial property. how and where do we stand vis-a-vis the enforcement of foreign matrimonial judgments? The fallback is on the Code of Civil Procedure of 1908, where section 13 and 14 deals with when foreign judgments are recognized, and they lay down the rule and they lay down the exceptions. So we strictly go by those rules. Now, the problem comes when there is a matrimonial judgment in a foreign jurisdiction or vice versa, because the execution is very difficult to prove and the system does not really provide very effective answers in this issue. Then another very interesting proposition which is coming up repeatedly now in matrimonial matters and which was actually a byproduct of commercial issues is anti-suits. So if you have two parallel litigations between the same parties, spouses on say marriage, say divorce, say child custody, you often now find one party going to the court and seeking an anti-suit. You cannot injunct the court, but you can definitely seek an injunction against a party who is in a jurisdiction. And there are instances where this jurisdiction is developing in the family law realm. So these are some conflict issues which have, according to me, gone into a major transformation. And law has primarily evolved on all these propositions, they're all 10 of them, through precedents of courts of law. Our system of Indian judiciary is very vibrant, is very flexible. The Supreme Court is not bound by its own law, though what the Supreme Court lays down is the law of the land, and different high courts do come up with interpretations, say on marriages, say on divorces, say on custody, say on religious beliefs, which tend to catch on as they go by. With the change of societal concepts, new issues keep emerging. What was acceptable 25 years ago, say live-in relationships, is now not accepted, but is now not declined either in case there is a benefit. There is a child of such a marriage, definite protection. A right to live, yes. So the courts from time to time change their views and go ahead. A very interesting example is that initially, when the Domestic Violence Act came, if there was a shared household in which the husband had no ownership rights, the Supreme Court said the wife had no right. But now, of late, the Supreme Court says no. If it is a shared household, it doesn't matter who owns it. The wife is entitled to live in it. So these are concepts which evolve with changing societal norms. As thinking changes, as we go into equality of spouses and freedom of thought, we tend to change our views for the benefit of society. And thanks to William, the International Academy of Family Law has transgressed into a new horizon. And the best part of the IFL for all young lawyers who wish to become family law practitioners is that every conference now carries an educational program. It is no longer the exclusive rich family lawyers exclusive club. They're open to memberships. They want like-minded people to join. They want people to learn. Whenever there is a conference, there is an educational program. We did one in India 3 years ago, and we did an educational program. We released one of our books, and William was very kind enough to open the floor to a full 2-day educational program in which issues were talked about. So the world is a global village now. And it is family law perhaps is the only law which has to probably fit in every jurisdiction and bind the people because of the human relationships which have come into it, which are impossible to divorce and which are impossible to ignore. And that is where people like William and the IAFL have brought in a big role. And I have seen the progressive views of the IFL in different conferences where we have been meeting, though we haven't done anything for 1 year. But at the same time, the foundation stones laid down by people like William have really gone a long way. And today's exposition by William, though in a different perspective, which is still we have still to reach, though because we are a different, our basis for law, family law is totally different. I thank William for giving this wonderful exposition and me taking the audience to an extreme opposite end to synchronize and be an equalizer to what the thoughts should be. Thank you very much.
Thank you very much to both speakers. I will now invite our participants for questions. But before I do that, there's one live question which we've received on our YouTube from the live YouTube telecast. The question is, how does private international law support the claims or causes of child abduction of parents of Indian origins?
William, would you like me to take
I
that?
think you definitely take that one, Anil.
Private international law or international family law is going to provide the answer on child removal for the simple reason that child removal has not still found recognition in statutory terms in India. So it is only by incorporating a definition of illegal removal or retention from the Hague Convention that the court can actually go into this jurisprudence. And having been a part of a committee constituted by the Government of India, where we have developed an inter-country child detention bill 2019, we interviewed people all over the world. We talked to them. There were 13 people, 6 judges, 6 government officers, and me. So this is something which was an effort of private international law. It is a banner of private international law under which we can step in to resolve this issue. Left to conventional Indian law, we would still be battling for a solution. So that is how people like William, international family law, people like Justice Thorpe, people like Anne Marie Hutchinson, who did a lot of work and who's no more with us today. These are people who took family law forward. And they are the ones who brought India on an international platform to say that child removal must find resolution. You cannot let people abduct their children and do all wrong things which they would not do if there was a law. If there was a system in place, this would not happen. And who will put a system in place? Private international law. Which private international law? The Hague Conference on Private International Law. Which law of the Hague Conference on Private International Law? The Hague Convention on Interparental Child Abduction 1980, which William said very rightly is the key law of the Hague Conference. I hope that satisfies the question maker.
Yes, I would now like to request Professor Ramakrishnan to ask a question, please. Professor.
Thank you, Ankit. And thank you, speakers. It was a very, very enlightening, engaging, educational session. So I have a couple of questions. The first question is regarding the interparental removal of children. When Mr. Malhotra was talking about the Indian scenario, the first thing that came to mind was this provision of the IPC, which is section 361, which talks about kidnapping from lawful guardianship. And there's this one exception to the section itself, which says that the section does not extend to any act of any person who believes in good faith to be the father of an illegitimate child or who believes that he is in lawful custody of such a child unless it is committed for an immoral or unlawful purpose. So I was wondering whether this provision has has it ever been problematic in the past? And follow-up question to that was, say for instance in the future India were to accede to the Hague Convention, would this provision have to be amended or modified in case it does end up being problematic? So that was my question.
Well, Asha, I'll answer your question straight away. There has been a precedent where the Delhi High Court held a father guilty of child abduction and invoked section 361, 363 and 365 of the IPC, that is kidnapping. He did not return, so it also held him guilty of criminal contempt. And the matter is in Supreme Court. I do not wish to give many details because I've just finished arguing that child abduction cannot be a criminal offense. And the IPC is not retracted because the natural parent cannot kidnap his own child. We do not fall into the realms of criminal law, nor does it satisfy the definition of abduction or kidnapping vis-a-vis the IPC or the Indian Penal Code is concerned. And going a little further, even though the Hague Convention on interparental child abduction, William would support me on that, uses the word abduction in its title. But when it actually goes to define interparental child removal or retention, it is in only or wholly in civil law realm. The purpose of the convention is not to punish the wrongdoer or to put an offending parent in jail. The purpose is to provide the child to return to the country of habitual residence. And the purpose is, in the best interest of the child, to have the privilege, benefit, and company of both parents, the best interest of the child. Now, in the Justice Jindal Committee report, which is in 2 volumes, which is available on the net, we have advocated the same theory that in Indian law, if and as when developed, will not have a criminal element or import on child removal. It will be wrong to develop a jurisprudence on the criminal law lines for children, child removal, because then you will be destroying the very basis of the entire exercise of developing a child-centric jurisprudence. The best interest of the welfare of the child under the United Convention on Reaching the Child is the child has a right to a family. A child has a right to both parents. A child has a right to a nationality. So if you want to put one parent in jail or punish him through the criminal law, it is an antithesis of the jurisprudence of the best interest of the child. So hopefully I pray that this never develops. And unlike the American system where child abduction is a federal offense, their thought is different on it. I may not agree with it. Their issues are different. They put you in jail if you abduct. That is the way of they're looking at it. But in India, we have not followed this regime. William would put us in light on the English perspective.
Yes, as far as England is concerned, it is a criminal offence. Just on the question of illegitimacy, it's quite important because, of course, illegitimate children, well, a father of an illegitimate child may not have parental responsibility in that child unless his name is on the birth certificate. And in those circumstances, the mother can take the child away if the father doesn't have the parental responsibility, and that is actually permitted, and that would not then be a criminal offence. So but of course, for many illegitimate children, the fathers do have parental responsibility because their names are on the birth certificate or there is an order of the court. But the default position where they haven't got the name is that they don't have that parental responsibility, which is an important element. I think we've got a question here, Ankit, on the chat.
Yeah, I was just about to read it. You can address that, then we have 2 more live questions, please. Thank you.
Okay, so I'll just have a look at this. This is to do with live-in relationships, common law relationships, in other words, where people are not married, and whether they have access to a shared property-like regime. I mean, property regimes, of course, do only come into being where the parties are married. But of course, I think the point of the question is, are there, if you like, is there something similar to a property-like regime? And the answer is that in many jurisdictions those exist. So, for example, you'll find that Australia has what they call the law of the de facto spouse, where somebody who's been cohabiting for a period of time has rights or responsibilities, which are similar to those of married people. Many of the states in the US have similar rights. What tends to have developed around the world with the rights for cohabitants is in fact not identical rights to the rights of married people. They're slightly different. Normally, they are rights to get what might be referred to as their needs dealt with from the court. They don't normally have a right to share in what has been created during the course of that relationship. And all the recommendations in England for rights for cohabitants, and there have been many of them, are to protect the financially vulnerable individual by providing him or her with what they need, rather than sharing in the overall assets. But there are many countries where laws have been brought in, and we watch them closely to try to copy them for ourselves.
Thank you. Professor Prasad, you can ask your live question now, please.
Yes, thank you. I hope I'm audible.
Yes,
Very much so.
Wonderful. My question was for William, and another one on cohabitation. I wondered if you could just tell us about your experience with cohabitation in practice, William, whether you get very many cases of cohabitation in your practice. And second, how different might your approach be to a breakdown of cohabitation dispute with an international element to it compared to a marital dispute that's similarly international? In particular, I was wondering about the jurisdictional considerations that you spoke about at the start with the French example you gave us.
Well, that's a very interesting question. Let's just talk about the sorts of cohabitation cases that I deal with. Most of the cohabitation cases that I deal with involve children. And in those circumstances, it doesn't really matter where the parties are living, because provision can still be made for the child. For example, if the child is living in England, well, even if the child's living abroad, under the Children Act of 1989, under Schedule 1, orders can be made where provision can be made for, let's say, the mother during the minority of the child. And the minority means up until the child is 21, so has finished probably their first degree. And that can be for accommodation, quite a lot of money sometimes. So, for example, there have been cases where a mother has got £3 million to buy a house in London, but she's had to give that money back when the child's 21. And then there will be a level of maintenance on top of that. So it might be quite a significant figure. For example, £150,000 a year has been awarded, but again, that only lasts until the child is 21. And then there can be some minor expenses which don't have to be paid back, such as the provision of a car, birth expenses, and so on. So that's the sort of order that can be made under Schedule 1. But for cohabitants where there are no children involved, they have to fall back on property law. And essentially, it's the law of resulting trusts or constructive trusts. So quite often, if people have been living in a house together, a promise might have been made, treat this property as 50% yours. We might be able to make a claim on that basis. Or if somebody has contributed to the building works on a house or to the mortgage, we might be able to make a claim on that basis. So those are the two different strands where we deal with cohabitants. Nearly all the cohabitation cases that I deal with involve minor children. It's not that usual to have cases coming forward where they're just dealing with it on a property basis. As far as the international element is concerned, as I say, the Children Act, with the Children Act, you have the jurisdiction to deal with people who may be living in another jurisdiction, and there are various rules attached to that. Otherwise, of course, I would be saying to people who, say, lived in more than one jurisdiction, check the law on cohabitation in the other jurisdiction, because it might be much more favorable than the law as it exists in England, because we are behind on this area, as I said. And of course, if we make an order under the Children Act, under Schedule 1, there is a question of enforceability, as there's always a question of enforceability of these laws. But the bottom line is, orders made in respect of maintenance, which can be interpreted as need, are much easier to enforce than orders in respect of division of property or capital. So that may be a major consideration depending on the other jurisdiction. I hope that deals with your question.
Yes, thank you very much, William.
Thank you.
I'd now like to ask Professor Upadhyay to ask his question, please.
Thank you so much, Ankit. Firstly, a lovely presentation, Mr. Longrigg and Mr. Malhotra. It was illuminating, and especially for a comparative international lawyer such as me. My question was primarily to do with ADR mechanisms and how they what role they play within the international family disputes regime, especially when it comes to financial aspects of divorces. And way more specifically, do prenups, and this stemmed more as a curiosity-based question out of Mr. Longrigg's presentation. Do prenups allow for, let's say, arbitration mechanisms to play a role, and have there been any success stories on that front when it comes to the the implementation of those clauses? Thank you.
Shall I deal with this?
Yes, William.
Okay, it's actually a very pertinent question, because many prenups contain a clause which says the matter will be dealt with by arbitration rather than in the court process. Arbitration in England has only been going in financial cases on divorce for, I think, probably 7 years now, and there are not that many cases. It hasn't really been taken up, although I believe that COVID is going to encourage arbitration very significantly. I've got a big arbitration on at the moment, which is sort of international. And the law has just changed on arbitration. One of the reasons that people have not been taking up arbitration as much as we thought they would is that it was very difficult to appeal an arbitral award. The law has changed. In fact, in December of last year, so only 2 months ago, from the Court of Appeal, which says there's no reason why an arbitral award shouldn't be treated exactly the same as any other court judgment, and therefore to be appealed in the same way. That's given reassurance to a lot of people, although in my case, which has just been arbitrated, it's rather annoying because the arbitral award was entirely in our favour, and now the husband's lawyers are of course going to appeal it, whereas before, frankly, they wouldn't have had a hope. So irritating, but there it is. Arbitration is going to be a major thing, particularly because the courts have got a bad backlog. Listing is difficult. Why shouldn't you go with a privately appointed judge who can be available within 2 weeks if he or she has a little bit of space in the diary? It's a brilliant system. In terms of other ADR, mediation, of course, is still a major thing in England, and many courts are expecting people to mediate prior to going to court. And in fact, there's an obligation to at least go to a mediation information session before you even issue proceedings. Collaborative law is another method of dealing with matters where the lawyers all meet together. They don't write a lot of unfriendly letters. They have friendly chats around a table. I'm a collaborative lawyer. I don't find it quite so useful because it's actually quite hard to get everyone together. Although perhaps now that everybody's on Zoom, maybe that's something that could be dealt with more efficiently. It's only recently that it's been very popular to put into prenups an arbitration clause. So I do not know of any situations where the marriage has broken down and arbitration has been the method. Arbitration can only be dealt with if both parties agree. In my opinion, even if a prenup says that they both agree that arbitration will be the method by which they sort out their dispute, I do not believe it will be enforceable without the agreement of both parties. That's my current view anyway. I should say, by the way, on prenups, in EU law, if a prenup contains an agreement particularly to do with which law should be applied, it can be seen as a binding, what's called an authentic instrument by an EU country, and is a very important document. Not necessarily the case for an English judge. It's a different matter.
As far as India is concerned, ADR mediation is statutorily provided in the Code of Civil Procedure. It is provided in the Family Courts Act, and it is provided in the system wherever, whatever law you apply to. But the success story is far, far away. The problem is the ADR or the mediator has no whip. He has no power. So the parties do not tend to listen. And the need to litigate and resort to an adjudication-based result is far more effective because it though takes time, it yields something which can be enforced. So the choice of mediation, though not catching on, is definitely a better way, because the family law queue is so long that for you to get effective relief in a short span of time when you need it the most, if that is not available, then there is no point. So we really need to develop an ADR in mediation. As far as prenups and arbitral issues are concerned, I think they're very far away. Only William has the benefit of enjoying those privileges.
Thank you. Thank you so much.
Professor Singh.
Thank you very much for the very good presentations. I have more academic questions rather than specific legal questions. I've posted them on the chat. From a UK perspective, post-Brexit, would a fallback to the Hague regime be beneficial in some areas? And what areas would be the losers? Like, I can think of recognition and enforcement of awards, which might be a little bit more problematic now. And a second question or comment is, it was good to notice the contract-based international family law system. I wonder if there are prenups in Indian family law already, or is there a move towards those, at least in case of NRI couples? Might the Indian system, first, are they already in existence? And second, do you see that happening in the near future?
William,
Anil, do you want to take the second question?
I will take the second part, you take the first part.
Okay, well, the first one, I'll just deal with it briefly. I won't go into detail because this is a really interesting question that we had, because I was on the Brexit committee of family law, which was advising the Ministry of Justice on the issues that were going to arise as a result of Brexit in the family law context. And people who were in favour of Brexit were saying, look, the Hague Conference on Private International Law is going to step in. And in fact, the provisions that they have, particularly in respect of children, are really very similar, and lots of other areas too, to the European instruments that we've been working on. And the people who were essentially against Brexit were saying, no, the reciprocity that's built up over decades is much stronger when it comes to the European instruments, and falling back on the Hague is essentially falling back on second best. Now, of course, some of us were quite heavily criticised by our American and Australian colleagues, of course, who had been looking at Hague much more closely because they hadn't ever been part of the European instruments. So they were saying, I don't know why you British are making such a fuss about all of this. We've been perfectly happy with Hague. So the answer to your question is that rather than going through these specific areas, there are lots of articles which exist, which go through, if you like, a comparison between the Hague regimes and the European instruments and compare them. And you'll see that people like commentators such as, for example, David Hodson, who is an English lawyer, is very much in favour of saying that, frankly, the Hague Conference and the Hague Conventions deal more than adequately with these things. Many other commentators say the opposite. So rather than going into any particular detail on that, I think it's a very good question. It's a very pertinent question, but I'm afraid that it takes real analysis to come to a conclusion about it. I hope that isn't trying to dodge your question too much.
Thank you so much. I'm sure a lot went into the negotiation.
It did.
So, Kritika, coming on to the Indian side, see, you have to essentially understand that there is no element of contract in our marriage. We are a religious-based, personal family law-based setup. So if conventionally in the Indian structure, you were to talk of divorce and parting and settlement after marriage, even before marriage, it wouldn't find acceptance in traditional networks of families. So prenuptials, being in the nature of a contract, having a contractual element, do not find a slot in the personal family law system. Even though you are married under the Special Marriage Act, but that ceremony, that keeping the marriage intact, etc., issue is overpowering to that extent. But dehors that thought. I, as a lawyer traveling all over India, doing cross-border transnational child removal and family cases, I find that certain segments in India where both parties are high net worth IT experts or high-end professionals who have only come in to get married at the traditional family home and who tend to live in the US or somewhere in Europe, they privately do work out an arrangement in the shape of a prenup. They are meant to be enforced overseas. They are not meant to be shown in India. They're not meant to be enforced in India. But the happening of people settling issues before they go away is coming up. Because nobody wants to go through a bad relationship after a parting. You don't want to fight on child custody. You don't want to fight on matrimonial assets. You want to be clear. You are mature enough to take a call that if there was a parting, this would be it. So prenuptials, though not acceptable in the legal regime, have an acceptance to a limited extent in the societal setup of a select category of individuals who are in a high network or high income group and who want to sort out things before they go away. So there is a limited perforation, as I would say, into the system, but we will need to evolve over it over a long period of time. It will not come in easily, but messy divorces, we still having a matrimonial cruelty concept under the Indian Penal Code, things like dowry, things like people putting people into jail for matrimonial offenses in the nature of cruelty or the provision containing to breach of trust. So all this is an antithesis actually to an anti-suit, to prenups. So till we are able to tone down Section 406, 498A, the criminal element, we cannot actually think of prenups. So I think we need another 25 years to get prenups into our system. And by the time William's next generation will be looking at all this.
Can I just add to that, as I mentioned in my talk, of course, prenups were contrary to public policy not so very long ago in England. And that was primarily because marriage was essentially seen as a religious sacrament, which the courts really didn't want to interfere with in that sense. And so I'm surprised at how quickly the attitudes have changed. So if you think it's a good thing to have prenups, which frankly I do, then maybe you'll be pleasantly surprised that actually it will come in rather sooner than you might expect.
You're right, William. This is a need-based involvement. It is a requirement of a couple or a family or of society. It has to come as a need-based requirement for an effective resolution rather than ugly, messy dispute lasting over 2 decades. So you think, well, let's sort it out right before we go into it. But this finding acceptance in the traditional family law structure in India is going to be a little bit of a slow process, I would say.
Thank you. Very interesting answers as well. Yeah, I think these were open-ended questions, but I did benefit from your comments. Thank you.
I may just add, I went to lecture on prenups and relationships in the nature of marriage and related issues in Symbiosis, Pune. The hall not only flowed but overflowed with students sitting all over the floor and everywhere. Because Pune is a city where students live in digs or apartments because there is not enough hostels. So this generation of young people were facing problems out of these issues, and they wanted to know what exactly is the future because they were already experiencing the nicks and knacks, I would say. So this is how law springs, evolution. Thank you, Kritika, for lighting the fire.
Well, I don't see any more questions now, so I thank everyone for joining. And the next lecture is scheduled for the 12th of February, and we'll now go into the United Nations system, and we'll discuss multilateralism in the United Nations. Rather different take on a different issue, comprises and comes very, very precisely in the theme, which is future of internationalism in international law. But thank you everyone for joining. Thank you everyone for watching in and tuning in on YouTube. Until next time, thank you very much. Thank you.
Thank you very much. Hope to see you somewhere in some part of the globe.
I hope to see you in person